Hi, I'm Alexa Nikolas, and we are Eat Predators. Eat Predators is a survivors-led movement. We want to make the world safe for survivors. Today, we are at the State Bar of California. Trigger warning. We are going to be discussing allegations of so trigger warning, trigger warning, trigger warning. What is the State Bar of California? California's official attorney licensing agency. It is responsible for managing the admission of lawyers to the practice of law, investigating complaints of professional misconduct, prescribing appropriate discipline, accepting the attorney member fees, and financially distributing sums paid through attorney trust accounts to fund nonprofit legal entities. Your opinion matters. We found this post on their Instagram page. Help the State Bar set direction and priorities for the next 5 years on admissions. Thank you. Here is an example of a past applicant. This story was released in the Daily Californian. ASCU VP to resign faces suit. Underage woman claims group attack by Bryan Hill. Facing a suit against himself and two UC Berkeley fraternities, newly elected ASUC Eternal Vice President Bryan Freedman said Friday that he will announce his resignation today. The suit asking $600,000 in damages was filed April 15th in the Alameda County Superior Court by and her parents, and it states that on October 4th, 1985, blank attended a joint Tau Kappa Epsilon Zeta Beta Tau party. Wow, isn't that a mouthful? At which members served her alcohol and failed to restrain others. Freedman, a member of the ASUC's Bears Party, denied there was or had been any lawsuit or incident. He said he is resigning in order to work for a San Francisco law firm and to better his chances of getting into law school. The lawsuit filed April 15th in Alameda County Superior Court charges Freedman and two others with blank, then 17, at a joint Zeta Beta Tau Tau Kappa Epsilon fraternity party last October 4th. Freedman said Friday that he has never been a member of any fraternity. He later denied having said this and acknowledged that he used to be a member of Zeta Beta Tau. Outgoing ASUC Executive Vice President Karen Licavoli, a member of the CalServe Party, said she had heard that the incident occurred in Freedman's room, but said she did not know if he had been involved. Outgoing ASUC President Pedro Noguera, who appointed Freedman's Attorney General in September, said that in November, Freedman told me in confidence that he was thrown up on campus disciplinary charges for involvement in the incident. Freedman said he brought her to the house, but after that, he was in no way involved and didn't know what happened. Quote from Bryan Freedman, "Let me remind you, I'm going to be working for a law firm, and if you print anything false, I will sue the paper and you personally." Freedman, who is facing a $600,000 lawsuit against him, two other men, and two UC Berkeley fraternities, announced last Friday that he would resign from his newly elected post on Monday to take a job at the San Francisco law firm. However, Gahn said he did not inform the Bears slating committee because he likes to play by the rules and did not want hearsay to screw up someone's life. Freedman said he planned to resign to take a career-oriented position with the San Francisco law firm of Dinkelspiel and Dinkelspiel. Freedman said he needed the job because his father was unemployed and he needed money to stay in school. On Sunday, Freedman denied that his father was unemployed. He said his father intended to retire. Ken Gooden, a member of the management committee at Dinkelspiel and Dinkelspiel, said that he cannot verify that Freedman has ever been in contact with the firm. "I have no knowledge of Freedman at all," Gooden said. Law firms don't interview undergraduates. So, when you are going to be applying for the State Bar, you have to do a moral character application. Here's our version of it. The Survivors Bar of California. Planet Here and Now. Instructions for application for determination of moral character. Please carefully read these instructions. Each applicant is required to be aware of all requirements that follow and to comply with each one that is applicable. The completed application form is for the protection of citizens. In answering questions appearing in the application for determination of moral character, applicants should consider the following. A. An applicant must be of good moral character as determined by the committee. The applicant has the burden of establishing that he or she is of good moral character. B. Good moral character includes, but is not limited to, qualities of honesty, fairness, candor, trustworthiness, observance of fiduciary responsibility, respect for and obedience to the law, and respect for the rights of others and the judicial process. If a law school applicant has been involved in a civil suit in regards to an alleged should they be obligated to disclose the complaint to the state bar when submitting a moral character application? Yes, because this will be a lawyer one day, and we want to make sure that they are a good citizen that also protects other citizens. 2, if an attorney has had allegations of should they disclose past civil complaints to a potential client who is a survivor of Yes, ePredators believes yes, they have to, because litigation is already an extremely re-traumatizing and triggering journey. And so we don't want to add anything more to that. Survivors deserve full disclosure. Should a law firm report allegations of by an attorney to the state bar? Yes, we believe that all allegations that happen at a law firm should actually be reported to the state bar and not just H&R, because unfortunately we've learned through corporate structures that H&R most likely silences the survivor and protects the alleged predator. So it's very, very important for the state bar to know, since they have the responsibility of regulating and disciplining these attorneys. Should an attorney with allegations of be able to cross-examine a survivor of Absolutely not, because it is extremely re-traumatizing as a survivor to go through the litigation process. So it's super important for survivors to have full disclosure. And I actually want to go back to this one right here because I double answered it. If an attorney has had allegations of should they disclose past civil complaints to a potential client who is a survivor of Yes, because a survivor deserves to know. They deserve full disclosure before they're hiring an attorney to represent them. Could that be seen as a perceived conflict? That's a question I have to the state bar. Would that be a perceived conflict? So if you have any type of allegations when you're applying for your moral character application, you must submit it with your moral character application. Mitigation, aggravation, rehabilitation. So the length of time since an act of misconduct is what they put into order. The severity of the misconduct and the number and frequency of acts of misconduct are given significant consideration. The following are additional factors that may mitigate or aggravate an act of misconduct or demonstrate rehabilitation. So they're basically suggesting that someone would have to go through rehabilitation before they can become a lawyer if they've had past allegations. Let's go through the timeline of our past applicant. So, University of California, Berkeley. The alleged assault happened on October 4th, 1985. The filed April 15th, 1986. So then in August 1987, he goes to Pacific McGeorge School of Law, submits his moral character application around November 1989, and then graduates University of Pacific May 1990. And in his third year of law school, he would have to submit his moral character application. He received his law license February 8th, 1991, which is interesting because most lawyers actually get their license around December. So why was there a delay? Was there an inquiry for more information? We don't know. That's a question I have for the state bar. But what's interesting about this is that apparently his case was not settled until March 13th, 1991. So they gave him his license in the middle of litigation. Why? Why would they give him his license in the middle of litigation when there's so many factors in the civil action that they have to pertain to and overlook and investigate? That is our question for this timeline. Your opinion matters. Another Instagram post from the State Bar of California. Help the State Bar set direction and priorities for the next 5 years on discipline. Figure 1, the State Bar's attorney discipline process includes multiple levels of review. Apparently, the State Bar is in the middle of a lawsuit right now for over $160 million about this specific issue. So, intake. When the trial counsel's office receives a complaint, it conducts a legal review to determine whether the alleged misconduct constitutes a disciplinable violation. In doing so, the trial counsel's office may close the complaint or forward it for investigation. 64.5% of cases were closed during intake. 22.2% of cases were closed during investigation. And then we go down here to 13.3% pre-filing of cases, went to 6.2% of cases were closed during pre-filing. 7.1% of cases went to hearing and discipline. Only 7.1%. And then over here, 1.8% of cases were closed during hearing and discipline without discipline. Here we go. 5.3% of cases were closed with formal discipline. And we go down here, only 0.5% of cases were closed with approvals of resignation with charges pending State Bar Court. 4.8% of cases were closed with suspensions and disbarments. Yeah, if it's only 0.5%, what's pretty interesting about that, it kind of just seems like a slap on the wrist, right? That would be like, let's say you had allegations of at college, and instead of like throwing you out or giving you disciplinary action, they just don't allow you in the yearbook. Just a slap on the wrist. There was a letter, the governor to California, President, this is Michael Tilden, CPA. Dear Governor and legislative leaders, the State Bar of California is responsible for protecting the public from attorneys who fail to fulfill their professional duties, and it works to meet this obligation by administering a disciplinary system that investigates and prosecutes complaints. However, our audit of the State Bar found that it failed to effectively deter or prevent some attorneys from repeatedly violating professional standards. We found that the State Bar prematurely closed some cases that warranted further investigation and potential discipline. We reviewed files for one attorney who has the subject of 165 complaints over 7 years, many of which the State Bar dismissed outright or closed after sending private letters to the attorney. Although the volume of complaints against the attorney has increased over time, the State Bar has imposed no discipline, and the attorney maintains an active license. The State Bar dismisses about 10% of all complaints using non-public measures, such as private letters, which did not deter some attorneys we reviewed from continuing to engage in similar misconduct. The State Bar failed to adequately investigate some attorneys, despite lengthy patterns of complaints against them. In one example, it closed multiple complaints alleging that an attorney failed to pay clients their settlement funds. When the State Bar finally examined the attorney's bank records, it found that the attorney had misappropriated nearly $41,000 from several clients. Finally, the State Bar has not consistently identified or addressed the conflicts of interest that exist between its own staff members and attorneys they investigate. We would like to investigate the State Bar of California. Power, institution, and authority. And I want the State Bar to listen to this. All is an exercise in power, but some have an edge that is more than physical. They operate within an institutionalized setting that works to their advantage and in which a victim has little chance to redress her grievance. In slavery and in wartime are two such examples, but may also operate within an emotional setting or within a dependent relationship that provides a hierarchical, authoritarian structure of its own that weakens a victim's resistance, distorts her perspective, and confounds her will. A therapist who suggests to his patient that the solution to her problem of frigidity lies in having with him is practicing upon a vulnerable victim. Although the patient may be slow to discover that she has been had, and a court of law would not recognize such emotional coercion as a forcible act, similarly, the glamour attached to cultural heroes, such as a movie star, sports figure, rock singer, or respected man in the community, provides a psychological edge that lessens the need for physical coercion until it is too late for the victim to recognize her predicament. Cases of celebrity pop up in the news from time to time and usually vanish again with an immoderate speed. These tainted from several angles: the glamour that emotionally disarmed the unwitting or foolish victim, and the fact that a victim has been foolish should not diminish the import of the offender's crime. Many robbery and con game victims are also foolish and unwitting, also acts as a shield in the defense. Police and prosecutors have little enthusiasm for ruining reputations over a charge of. Not only is the victim's response during the act measured and weighed by her past history, is scrutinized under the theory that it relates to her tendency to consent, or that it reflects on her credibility, her veracity, her predisposition to tell the truth or to lie, or so the law says. As it works out in practice, juries presented with evidence concerning a woman's past history make use of such information to form a moral judgment on her character. And here, all the old myths of are brought into play, for the feeling persists that a virtuous woman either cannot get or does not get into situations that leave her open to a. The law must rid itself of outdated masculine concepts. Silence is violence!
Silence is violence!
Silence is violence!
Silence is violence!
Power to survivors!
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 Stick it to the man!
And 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 stick it to the bar!
Stick it to the bar!